Ndị Igbo ekene m unu. Asị m ka nke echukwelu ya zelu. Anyị si ndụ mmiri ndụ azụ, mmiri atara m azụ anwụra. Asa dịrị mma na eke, dịrị mma n'orie, fọzara mma n'afọ, fọzara mma na nkwọ, ụzọ ahịa anọ nke ndị Igbo ji biri. Asị na ya dịra n'Igbo na mma o. Ise, ise, ise. Dịka o si dị ka agbapụ na ya ọsọ igosi na ya bụ ife anyị ji maka ya wee bịa. Na tupu anyị aga n'igosi na ya bụ ife, ọ bụla nke a bụ ụbọchị izu gị, ị na-ejete afụ chanel anya n'igbe akwụkwọ ka baro ka ị like and subscribe ọ. Tinyekwa kọmentị, share ekwe ya, tụsa ya bụ ozi ka ụmụnne anyị dị n'ebe dị iche iche wee nụ ya bụ ife na-eme n'obodo a. Dịka o si dị, ihe wetara unu tata bụ nnukwu ọpdeti dị oke mkpa. Mma nchọ ka onye ọbụla misie ya, mma nchọ ka ị ga ya bụ ife, ị ga-esi ya bụ ife wetara unu gbasa maka ya bụ ife na-eme n'obodo anyị nọ n'ime ya. And nwere onwe ndị Igbo na-azọ drọpụra ya ọnụ kọmentị n'ihe a nwanne anyị nwoke kwuru n'iru akwụkwọ dị oke mkpa ka anyị mara ife iche n'ụdị nke gị. All right, over to you, sir.
The three of Nigeria's aircraft in Paris, France, following the order of a French court due to a dispute with Ogun State, has released one of the aircraft, an Airbus A380, recently acquired to replace former Air Force One. But Zhongshan Fengzhen Industrial Investment Company still held the two of the country's aircraft. This was as the federal government stated that it was taking steps towards resolving the dispute. Foreign Affairs Minister Yusuf Tuga, who reacted to the matter, attributed the dispute which resulted in the impoundment of the aircraft to the wrong handling of international affairs by some subnational actors. Following an arbitration judgment in favor of the Chinese firm, a Chinese court had on August 12 ruled that the judgment creditor could attach any of Nigeria's assets abroad in payment of the judgment debt. Joining us now on the show to analyze the judgment which favored the Chinese firm is Michael Kaso Andoaka. That's Nigeria's former Justice Minister and Attorney General of the Federation. Great to have you again. Let's clarify something. The judgment given in China that was said that the company could attach any of Nigeria's assets anywhere in the world. Is that right? Because some people also argue that they should have just dealt with Ogun State government asset, not Nigerian government assets in the first place.
Well, thank you very much. Ogun State seemed to be part of the country. And when you are dealing with a treaty, it was the federal government that actually entered into that investment treaty. It was done in 2001, signed by the Minister of Industry. And I've seen the contents of the treaty, very strong contents of the treaty. I was very worried whether the Minister of Justice, even that of Ogun State, or Minister of Justice of Nigeria was consulted. The first issue, I look at Article 14 of it, Article 4, which talked about expropriation, which is that's a new development in international arbitration. Expropriation, which means if you enter into an agreement and the state takes steps adversely that depreciates your investment, then you can have compensation. I don't know whether they knew what they were signing. That is including even why you have contracted and the state now changes the laws in such a way that they operate detrimental to you. Is there Article 4? And I was shocked that somebody signed it. That is the beginning of the problems we had. And then you are dealing with an arbitration. The treaty had three areas, two strong arbitration clauses in paragraph 8 and 9. The best venue we could have got was one of the paragraphs gave a right to court. And these people had attempted to go to court in Nigeria. If we were clever, we would have had a contact claim. Even when they withdrew their action, they wouldn't have resorted to going back to arbitration. But there wasn't a contact claim because you have alleged that they violated some of the terms of the contract. That must have been the basis on which Ogun State terminated. And therefore, when they filed action in the first instance, Ogun State ought to have raised a contact claim. I did not know why they didn't, because if they have raised a contact claim, Even if you withdraw your action, the contact claim being a separate cause of action, it would have remained. And that would have been the live wire of it. But then there was provisions for arbitration. Comes to the arbitration, international arbitrations, especially when they're embodied in a treaty, you have to be careful. I went through if you draft a fluid arbitration treaty, you are creating a time bomb for yourself. I look at the arbitration agreement. The arbitral provisions did not make provision for the seat of arbitration. That is the place of arbitration. And it left it hanging to the arbitrators themselves to decide the seat of arbitration. And they decided the seat of arbitration in London. And normally when the seat of arbitration is in a particular country, the local courts become the courier courts. They become the couriers. And the applicable laws for the operation, for conduct of arbitration becomes the laws of that courier court, even though reference can be made. So if you see there's a foreign investment act of London which specifically exclude state immunity from commercial transaction. That is, I was so shocked that is where I don't know what to say. But if you look at the issue of attachment of presidential planes, that is where completely the foreign firms are wrong. Sovereign immunity operates in two ways. Though before the New York Convention, which Nigeria is a third party, 160 countries have signed, there was absolute immunity, sovereign immunity. But after the convention, which now recognition and the enforcement of arbitral awards in foreign awards, it became an international treaty which Nigeria signed and demonstrated in 2023. And after that, you have the Singapore Convention, which I understand Nigeria has recently signed. They are also incorporated specifically in our laws, Arbitration Act. Now come to the issue of the enforcement. The arbitral proceedings took place, and I am afraid the issue of jurisdiction was not raised. I saw a clause where diplomatic channels have to be used first, which could have availed Nigeria at that time. I don't know whether it was exploited because it would have been, action going to arbitration would have been premature if diplomatic channels were not first employed because it's there in the agreement. That I'm not aware. I don't know whether it was used, but it was not used. It was wrong. But then, Nigeria having participated by nominating an arbitrator because the treaty made provisions for 3 arbitrators. Each party nominates one, and then they nominate the third party who must be outside the contracting party national. If Nigeria nominated an arbitrator and participated in the arbitration, then these other issues of not exploiting diplomatic immunity seem to have been waived. These are the issues. But now, sovereign immunity operates in 2 ways. What the appeal court in U.S. dealt with was the procedure aspect. I'm afraid when people will say, appeal court say, or U.S. say they can attach Nigerian properties everywhere, I don't think that was an extreme position by those who fight to frighten the country. It has to do, recognition of award has to country by country. When you register, the country will evaluate it. And 2 areas the country will look at is did the arbitrators who rendered the final bidder award exceeded their jurisdiction, or was the arbitral award contrary to public policy? Nigeria is now hinging on the issue of public policy. That is it. But of course, issue of sovereign immunity. But now where I have a major quarrel with the Chinese people is that the sovereign immunity, even though after the convention, the New York conventions have been classified into two. Absolute sovereign immunity, properties that belong to the state which the state uses for operation of state, not for commercial basis, are immune. They are considered sovereign immunity. For instance, military hardwares, presidential planes, because presidential planes are not used for the purpose for commercial purpose. Presidential planes are used basically for state functions, and those ought to enjoy absolute sovereign immunity. Sovereign immunity, which I am afraid I don't understand the basis in which, especially like money in the treasury, that is central bank, you can attach because it enjoys sovereign immunity. By here, these are presidential planes. You have to lead evidence to show whether the planes seized are for the purpose of commercial transaction. I can't see have a president plane anywhere in the world, including China, can be used for commercial transaction. So I am still thinking Nigeria have a strong case to make to retrieve those presidential planes because they enjoy absolute sovereign immunity.
All right. Thank you so much, sir. You've raised some critical points in this case, and thank you for that. Number one, where you talked about they didn't raise the issue of jurisdiction. That's an important fact. And, well, in terms of companies or organizations or even sovereigns wanting to approach other courts, like you've cited, because of maybe the belief in their justice system. But again, that could be a case for Nigeria. But I'd like you to please touch on the fact that the point of view from Senator Ibikunle Amosun, who's come out to defend his point, saying that he entered into that agreement based on falsehood. He even admitted that he didn't quite read the terms, or assess the deal adequately before he entered it, hoping that it would be a temporary measure whilst they investigated the agreement that had been signed by the previous administration. He likened it to the P&ID case, which you played a critical role in. And I'd like you to share, does it have merit? Is there any similarity between this particular incident and the P&ID situation, which after going through, court cases, then, became obvious that was a scam, and Nigeria was awarded $20 million, which £20 million, which the Chinese company are now saying they want to confiscate as part of their measures to get their compensation or to get that award given to them by the courts. Is there any similarity between this case and the P&ID case?
Well, I don't have enough evidence. P&ID is a debt with me because I was the Attorney General, and they didn't sign the agreement purported to be signed by my subordinate, which that it is an infraction. And then P&ID was an infrastructure concession where similar to this one, but there was no treaty. There was no national treaty guaranteeing investment by P&ID contracting party into Nigeria. But here you have a treaty between the government, People's Republic of China and Nigeria, which guaranteed all contracted investors, which is broadly defined, into Nigeria, and gave them even a provision for expropriation, which means you cannot take over the asset. You can't nationalize without compensation. So the things seem to be a little similar. And of course, it doesn't make sense to me, I must be honest, when somebody signs a document and comes, I did not read it. Because document once reduced into writing is bound, you are bound by it. It doesn't make sense. We can make better sense by saying that, look, national assets are threatened, because we also have some cases where minerals, international cases, where mineral resources are considered as national assets. And a free trade zone can be viewed as also a national asset. There could be better arguments than to say I signed an agreement and I did not know about it. Why were you signing an agreement without knowing something about it? What was the basis? And the specific findings here, if you read the judgment of the appeal court in U.S., finding where the people laid evidence that they did investment, made construction, paid taxes, and there was some pieces of evidence that went unchallenged. And you to come back here and start talking that the P&ID is a standard local classical that where corruption, crime is visually established, then you can kind of vitiate. Public policy say where crime is involved, arbitration cannot hold. But we're not talking of P&ID here. P&ID where a group of people came to scam and did things in a manner that were contrary to all the laws, and there was no law protecting them. There was no state treaty protecting P&ID to get into criminality in the manner they went. I participated in P&ID. Me, Tayo, and Apan and Dokpe, we were the Nigerian team. So I knew everything that went through. And apart from me, I was Attorney General. So you can't just bring something that you did wrong. We have hopes in this case, but not from the approach of saying, I did not know. There's finding here that the people were locked up. The Court of Appeal in the USA, the people were locked up, detained, that they got a text message that they're going to be arrested. They were detained by police. This is using state. This is the issue. You have paragraph 4 of the treaty which say expropriation should not. But you are using state action against these people, which is findings made. I don't know whether we denied it in the proceeding or not. This is the problem. So somebody to woke up and say that I signed something and I did not know is Rufai. I don't think that makes sense. Does it make sense to you?
It doesn't. Rotus.
Yeah. So okay. So based on that, how do you think what's going to happen as far as the judgment is concerned? If it sounds like it's incompetence, right? If it's not corruption, right? Because of what the statements that have been made. So how do you think the case will end? And then 2, 1 plane has been released, 2 are still being held. Was that plane released in good faith? How do you think the case moves forward from here?
Where the Chinese people ought to release our planes, because on the doctrine of sovereign immunity, they have no right to attach presidential planes because they are not for the purpose of commercial transaction. If a state goes into an investment, even in Nigerian law, like the federal housing, try to say that they have the only federal high court can regulate them when they went into a contractual relationship with somebody. The Supreme Court said, no, you are no longer acting for declaratory actions, but the state now has created a vehicle to do business. So the transaction will go to our ordinary high court of a state, which has unlimited jurisdiction to deal with contract matters. So here, if the state waives, for instance, in England, particularly where the seat of arbitration was conducted, and I told you the influence of the Korea courts and the laws where the place of arbitration is taking place, they specifically excluded where the state goes into transaction, commercial transaction, the state cannot claim sovereign immunity. It's there. So it's commercial transaction. Our planes are not used for commercial transaction. Presidential planes are not used for commercial transaction. So, and then let's find out, arbitration recognition is not done in absentia. You must go to that country, you must file notices for recognition, application for recognition and enforcement. So what happened to Nigerian lawyers when they will serve these processes for enforcement? What did they do to protect the planes?
Okay.
Because it's clear in there that the sovereign immunity guarantees Nigeria presidential planes because they are not used for commercial transaction. What did our lawyers do before they were seized? Because they must have been served the process.
Okay, so part of also the story, before that happened, that they went to our planes, the sovereign immunity was pushed aside. I think it was when they went to America and New York court to be able to talk about the arbitration because they had filed cases everywhere. And the sovereign immunity thing was pushed aside. And that's why they had access to our planes in the first place. So I want you to talk through that. On what conditions can a sovereign immunity...
No, the sovereign immunity in the appeal was in relation to the procedure. Because the planes were not the basis for sovereign immunity claim. It's the procedure of recognition and enforcement. Please. Sovereign immunity was not the basis. Because they could not say that the procedure, I'm going to seize planes. They were seeking recognition of the award, which was the procedure. Was the procedure for this award regular, right? Is it contrary to public policy? It is this. And then we raise issue of sovereign immunity.
Ndị be anyị ekenekwa m unu dịka unu si wepụta oge unu igekwa ya bụ ife nnukwu ozi dị oke mkpa eji maka ya wee bịa n'iru akwụkwọ na Igbo Media bụ ebe anyị si wee na-wetara unu ya bụ nnukwu ozi dị oke mkpa gbasịta maka ihe na-eme n'obodo anyị nọ n'ime ya, ana gbasịta maka nnwere onwe ndị Igbo na-azọ, ana gbasịta maka Maazị Nnamdi Kanu ladies. Dịka ị nụrụ ihe nwanne anyị nwoke kwuru n'iru akwụkwọ ka efi were ikwu n'ụdị nke gị asị gị kwuo ka efi were ikwu maka na otu aka o jedebe njọ ọ ya adịkwanụ mma. Ọkwụ na ọtụ ụmụnne m, achọrọ m ka unu tinyere anyị alụ nkwu na ife unu chere n'iru akwụkwọ ikwucha ya bụ ife kapa arụsie ya kwurụta ụmụnne anyị ndị ọzọ ntị darụrụ ine na ụmụnne m kpọmọ na-ege ntị. Anyị na-ekene ndị nnekunu si na-esoyere anyị esiri ngwa nke mesịa n'ụmụ Igbo.